Yes. Any mention? No PIL. Thank you. We'll see you in the single bench.
May I please, Your Lordship, item number 6 and 7.
Yes.
Lordship, we need 1 week time to reply the affidavit.
What affidavit?
Rejoinder affidavit, Your Lordship.
Oh, you have not filed your rejoinder. But
Not
this is in the hearing.
Your Lordship, what had happened, Your Lordship, during initial days, Your Lordship, we have filed the affidavit in opposition. And then the matter was transferred from Court 2 to Court 3, Your Lordship. The petitioner objected that we haven't provided them our annexures, Your Lordship. And then subsequently, we have provided them the annexures and they said they want to file the rejoinder affidavit, Your Lordship. And that's how, Your Lordship.
If that is the case, then you should not have made a mention for. If you wanted to file your rejoinder, it has to be, it has to be heard. And I'll hear your submission and I'll pass this order. Mention is only for seeking adjournment on personal grounds or otherwise.
We need some time, Lordship.
Exactly, we need that. Then you make your submission when the matter is called up.
Okay.
I will allow your prayer. But this is not the, this is not the time.
Okay.
Six and 7, Your Lordship.
Let the matter be called up.
Much obliged.
Please, Your Lordship, I beg to mention item number 9. I pray for 2 weeks' time, Your Lordship.
What is your ground?
Your Lordship, senior counsel is in some difficulties there, Your Lordship.
On pre-made by petitioner, this is matter up to 3 weeks.
Your Lordship, similar prayer for item number 10, Your Lordship. Your Lordship, we have received an additional affidavit here, Your Lordship. We would want to show it to the party.
Already filed, Your Lordship. That was the notification issued last year, Your Lordship. The order, Your Lordship. Extending the term of the suspension, Your Lordship.
Oh.
That notification only.
On pre-made by the petitioner, this is matter up to 2 weeks.
Much obliged.
Okay.
I can see. But here, affidavit I am filing today, my lord.
Item?
Item 6, my lord, of the hearing. Apologies, my lord, item 4 of the hearing. I'll be filing it today, my lord. I would have filed it yesterday, but Lord, actually I was not keeping well, so I'll file it today.
The last chance given today.
No, I am filing it today only. It is already there with me.
On pre-made by the GA, appearing for the state respondent, seeking accommodation on grounds of personal difficulty, that is adjourned. This session up to 1 week.
Can it be fixed on 21st, Lordship?
Let it be one. We have to see how the boat is made up. If they're fixing matter on a particular day, it may be too many or too less.
My lord.
We'll see.
Masa.
Right, my lord.
Daily list, item number 1.
May it please, Lordship. Lordship, this is a case where state has challenged the order of Lokayukta directing registration of FIR against certain private individuals. Case of the state is, my lord, that this is beyond the power of Lokayukta to issue direction for registration of FIR, because for registration of FIR, either this honorable court or the magistrate under 156(3) can pass the direction, my lord. There is no power vested with Lokayukta. That is the main challenge, my lord. Yes, there is no power in the Lokayukta Act that conferring power on Lokayukta to direct registration of FIR against private individuals. There is no such power in the Act. So it goes beyond the Act, but the issue right now before your Lordship is that when the writ petition was filed by state government, my lord, At that point of time, inadvertently, Lokayukta was also impleaded as party respondent in the writ petition, my lord. But on examination and detailed examination of the Act and provisions, it was noticed that Lokayukta is exercising quasi-judicial power. It's like court, mini court. It has got the power of the court. And Lokayukta cannot come and defend its own order. It's like judge coming and defending its own order. So we moved deletion application, deletion of response number 1 and 2 from memo parties, which is being opposed by Lokayukta. So that application is listed before your lordship for hearing. So I wish to...
So let us see. Let us look at a situation
Yes.
where a certain order of the Lokayukta is impugned.
Yes, Lord.
The Lokayukta may be a party, may not be a party, in personal capacity or otherwise. Who is to defend that?
That will be defended by the complainant, my lord. Complainant is the person. Complainant has moved against the private persons and government officials. In all matters, my lord, your lordship is aware that there are two parties, one private person and the complainant and the other side. So the aggrieved person would be the complainant, my lord. Lokayukta has no jurisdiction to say that my order is of directing registration of FIR is correct, because Lokayukta is a judge. He is exercising quasi-judicial power. He is exercising powers within the Act. So judge will not come and defend, like it's like district judge coming and defending her or his own order. That is not the law, my lord. That is not the... So therefore, being a writ petitioner, my lord, a state is a writ petitioner. A state is aggrieved with this kind of direction which are beyond the purview of the Act, my lord, because if somebody gives the direction that to the state to do certain things which is not in accordance with law, state is surely aggrieved party, and therefore that action or that list will be contested by the complainant, saying that either my case is right or wrong, but that will be contested. But Lokayukta can't come and decide the matter, my lord. This issue in fact was also seen by Madhya Pradesh High Court in one of the judgment, which I have annexed in my application, my lord. If I can place that application of...
The this complainant is here.
He's kindly see my application, my lord. Paragraph page 4,
Will this
page
be,
3.
Mr. G, will this be a long drawn hearing?
It will take some time.
My lord, from my side, I have just one judgment to place for lordship's consideration, subject to whatever other things my senior states.
So we'll just finish off with the order matters,
Very good, very good.
and then we'll come back to you.
Yes, lord.
Item number 2.
May it please your lordship. Yes. Lordship, that is a remission matter, your lordship.
What is the decision of the Supreme Court?
Lordship, it appeared to be still pending, your lordship. Petition also is absent, your lordship.
None appears for the petitioner. Mr. Ndishwara Landed AAG has submitted that till date the matter dealing with the issue raised in this petition, which is now pending before the Supreme Court, has not yet been disposed. Under such circumstances, the AAG has prayed that this matter may be put on hold for the time being.
4 weeks, your lordship.
As prayed for, matter is adjourned. This is matter after 8 weeks.
8 weeks.
If any order, if the matter pending before the Supreme Court is disposed of in the time before such date, the parties are free to make a mention of the same before this court.
Apply, Your Lordship.
Item number 3.
Please, Your Lordship. Your Lordship, in this matter, last date I have asked 3 weeks time to file the counter, Your Lordship, for respondent 4 to 10. But when I'm looking at the pleadings, Your Lordship, the translation for the order which they have challenged has wrongly been translated, Your Lordship.
What is the you are referring to?
Lordship,
Which annexure?
Page 211, Your Lordship. The paragraph number 5, page 211.
111.
Yes, Lordship, this one has been wrongly translated, but only second line, Your Lordship. He cannot claim himself as Sardar of not right tendering as whole, but he can only the Sardar Rang Bashnong of not right tendering. The District Committee has ordered CM of Himakharim, Asim Wakram Nakram to rectify the Sardar of to be the Sardar of not right tendering. Here, Lordship, the original copy is at 216, Your Lordship. 216. Paragraph 5, Your Lordship. Discussive version, Your Lordship.
Yes.
Second line, Lordship, Umtan Numla Shu Bandang Kambat Trikam Kom Soda Gasna right tendering, he broke away, Hendry Lapat Banlong, Usada Sunong, Tang Josh not tendering. Here the order is regarding headman, but when they translated is as the Soda Rang Basnong of not right tendering, Lordship. There's a difference of the translation is not correct, Lordship. So I cannot file proper affidavit on counter because the order we have challenged is not proper.
This is the impugn order.
Yes, Lordship.
Lordship, I'm appearing for respondent number 11 and 12. I'm the chief, Your Lordship, where the petitioner is under my local jurisdiction and all other individuals, party respondents. Your Lordship, I just have 1 point, 5 points, Your Lordship, to make my submission. First, Your Lordship, there are many traditions and
Mr. Doctor, this is not the.
Yes, Lordship.
just for to give.
I want to file the counter, Your Lordship.
First, let us finish with the pleadings. Have you filed your counter?
Yeah, I will file. Yeah, within a week.
That's the only rectification because this is the impugn order, Your Lordship. So,
To clarify, Your Lordship, this is a Khasi translation, so I'll clarify with my colleague.
Yes, you get a proper.
Your Lordship.
Mr. Bikram, letter counsel for the respondents.
4 to 10, Your Lordship.
4 to 10, respectively, has submitted that the annexure, the impugn order at annexure.
Annexure 11, Your Lordship.
Not even properly marked here.
Page 206, given annexure 11.
206.
206.
The annexure 11. Kunum to go.
This one, no, sir?
Has not been properly, has not been correctly translated. Correctly translated, comma, on comparison of the translated version at page
216, 216.
216 of the petition herein, and as such no effective counter could be filed under such circumstances. Ms. Learned Counsel for the petitioner, on the other hand, has submitted that some time may be allowed for the petitioner to look into such to look into the matter and to furnish an authentic translated copy of the impugned order. This being the case, the parties are allowed to take necessary steps and to make the necessary correction as and when make the necessary correction. How long?
2 weeks time, Your Lordship.
As prayed for, this is matter up to 2 weeks.
Ashok.
2 weeks then. Yeah, number 1.
Second call, item number 1.
Petitioner might have abandoned the battlefield.
No, Lordship. Lordship, the application will be it's also.
There is some time lag in YouTube, my lord. So I was placing my case, my lord, on the issue of Lokayukta right to be party.
Yes.
Because I am the writ petitioner, my lord, and I do not wish to implead Lokayukta as a party. I am dominus litis, my lord, and I have a right to implead who should be party, who should not be party, my lord.
So this is your domain.
It is my domain, my lord. So therefore, on this ground alone, my lord, in my humble submission, Lokayukta can't say that I am a necessary party and you must implead me party to the writ petition. That is the first argument, my lord. That I am dominus litis, I have domain, and being a petitioner, I will choose who should be party and who should not be party, my lord. That is my first argument. Or this court may direct that Lokayukta, this court has ample power, this court may direct that Lokayukta can be impleaded as party, but
That is only when the, you see,
only when the law.
when it is
Yes.
apparent that they are proper necessary party.
Yes, Lord. I am highly obliged, my lord. That is my argument. Now, if your lordship will see the Lokayukta Act, my lord, we have given a compilation, the nature and function of Lokayukta, my lord, in which the various powers are exercised by Lokayukta, my lord. Lordship, this is the compilation, your lordship.
compilation.
Yes, lordship. Kindly see the first, your lordship will see section 2C. C is chairperson, means the chairperson of Lokayukta, my lord. Page 2, my lord.
To see, yes.
Then your lordship will see section 2J at foot of the page of page 3.
Yes.
I am taking your lordship through the various provisions of Lokayukta Act to show that nature and function of Lokayukta under the Act, my lord. Lokayukta means the body established under section 3, my lord. Your lordship.
Sorry for interruption. If it is applied, the copy of that comply this into us.
Yes, yes. You are entitled to.
Yes, please.
You could have asked for a copy, I would have provided. There was no need to go to the court. 3.
The code is more approachable than the others.
We can trouble your lordship only when we cannot resolve our issue among ourselves, my lord.
Please continue.
Yes, 2J, my lord. Lokayukta means the body established under section 3, my lord.
Yes.
So this is a body established under Lokayukta Act, my lord. Then your lordship will see 2N at page 4. The definition of public servant, my lord.
Yes.
Public servant means a person referred to in clause A to H of subsection 1 of section 14, but does not include a public servant in respect of whom the jurisdiction is exercisable by any court or other authority under Army Act, any Air Force, Navy Act, Coast Guard, or procedure is applicable to such public servant under those acts. My lord, so the definition of public servant has got 2 components, my lord. That the public servant defined under section 14 A to H, and my lord, but does not include public in respect of whom jurisdiction is by any other court. So if there is a jurisdiction of any other court, criminal court or session court or civil court, the public servant has to fall between A to H of section 14. So then the jurisdiction of Lokayukta will apply to public servant which are defined under section A to section H of section 14, my lord. This is the definition of section 2N, my lord. Now, my lord, section 3, my lord. As soon as after commencement of this act, there shall be established by notification in the official gazette a body to be called the Lokayukta. So there will be Lokayukta, my lord, under the act. I skip that part, my lord, not very relevant for time being, my lord. Then your lordship will see section 11 at page 9, inquiry wing.
Page 9.
Page 9, section 11, my lord.
Yes.
Notwithstanding anything contained in any law for time being in force, Lokayukta shall constitute an inquiry wing headed by Director of Inquiry for the purpose of conducting preliminary inquiry into any offence alleged to have been committed by a public servant, my lord. Kindly mark, public servant punishable under the Prevention of Corruption Act, provided till such time inquiry wing is constituted by Lokayukta, state shall make available such number of officers and other staff of its department as it may be required by Lokayukta for conducting preliminary inquiry under this act. So then there is an inquiry wing constituted under the act which Lokayukta will have. Then similarly, my lord, section 12 at page 10, there is a prosecution wing.
Yes.
The Lokayukta shall by notification constitute a prosecution wing headed by Director of Prosecution for the purpose of prosecution of public servant in relation to any complaint by Lokayukta under the act. So there will be inquiry wing. First, your lordship, I have shown who is public servant. Public servant is one who is defined under section 14 A to H. Then I have shown to your lordship inquiry wing. Then prosecution wing, my lord. So this is then your lordship will see power of Lokayukta at section 14. Now your lordship will see the marginal heading, jurisdiction of Lokayukta to include so and so. Then subject to other provisions of this act, Lokayukta shall inquire or cause an inquiry to be conducted into any matter involved or arising from or connected with the allegation of corruption made in the complaint in respect of the following: any person who is or has been. So then these are the persons, my lord. Your lordship has seen definition of public servant from A to H. So these are the persons named in from A to H are public servant, in respect of which Lokayukta has power to conduct the inquiry, my lord. And this is the under the act, it will come under the jurisdiction, my lord. Then your lordship, kindly see section 19, section 18, section 18 and 19, my lord. Sorry, 19, my lord. The process of decision making, my lord. Because when the complaint comes, how it has to be decided, my lord. 14 I have shown, my lord. And then 19 is that this decision will be by majority, my lord. Section. If a member of bench consisting of an even number of members differ in opinion on any point, they shall state the point and point which differ and make reference to chairperson.
Mr. AG,
Yes.
the Lokayukta is a single member body, isn't it?
No, single member body. What I was trying to show that there is a decision. Now it is a single member. When the originally act was there, my lord. The point I was trying, the purpose for which I am section 19, I am showing, my lord. It is a single member, but there is a process, decision making. It's a complaint will come, judicial decision will be taken, and for that purpose only, I am trying to show, my lord, section 18 and 19 for limited purpose only, that there is a decision making process.
In the light of the subsequent amendment.
Yes, my lord. This has to be modified, my lord.
I don't know why.
Yes, my lord. I can leave this part, my lord, and then now 20, my lord. Section 20.
Yes.
The Lokayukta shall, on receipt of complaint.
Yes.
Section 20, my lord. Lokayukta shall, on receipt of a complaint, first decide whether to proceed in the matter or close the same, and if the Lokayukta decides to proceed further, it shall order the preliminary inquiry against the public servant by its inquiry wing or any agency to ascertain whether there exists a prima facie case for proceeding in the matter or not. During the preliminary inquiry referred into subsection 1, the inquiry wing shall conduct preliminary inquiry. So, on Lokayukta, on a complaint. So, complainant is before your lordship. Before Lokayukta, the complainant came and made a complaint to Lokayukta, saying that so and so are public servant, they have done some act under PC Act, and therefore please examine the matter, my lord. This is the nature and jurisdiction of function which Lokayukta can exercise, my lord. And then your lordship will see 19. I have already shown, my lord, 20. I have shown 20, my lord, and 55, my lord, is the your lordship will find at page.
Yes.
As page 31. Lokayukta shall provide every person against whom a complaint has been made before it. Under this act, legal assistance to defend this before Lokayukta if such assistance is requested for. So Lokayukta, my lord, and Lokayukta is also having power of civil court, my lord, that your lordship will find those provisions. Which one? 20. 27, my lord. Paragraph section 27 at page 18. Subject to provisions of page 18, section 27.
Yes.
Subject to the provisions of this section, for the purpose of any preliminary inquiry or inquiry wing of Lokayukta shall have all the powers of civil court under the Code of Civil Procedure 1908 while trying a suit in respect of following. So, my lord, it is a body which is having judicial or quasi-judicial power. My second submission, first submission, my lord, I am dominus litis and I can choose who can be party or who cannot be party. If there are necessary party, your lordship may order. Second submission is, and your lordship, I am grateful, kindly see 27.2 also, my lord, of page 19. Page 19.
Yes.
Which leaves no manner of doubt that it is a judicial proceeding before Lokayukta.
Yes.
And page 19, Your Lordship has seen subclause 2 of 27(2), my Lord. Any proceeding before the Lokayukta shall be deemed to be a judicial proceeding within the meaning of section 193 of Indian Penal Code. So it is a judicial proceeding. There is no scope of doubt, my Lord, that the proceeding before Lokayukta is not a judicial proceeding. Now the question which falls for Your Lordship's consideration is whether in a judicial proceeding, a judge or a person who is presiding the judicial proceeding is a necessary party to a case before Your Lordship, whether he has a right to defend his own order which he has passed in the judicial proceeding. So there is no dispute so far as the nature and function of Lokayukta is concerned. It is a judicial proceeding. So my second submission, my Lord, is flowing from this, my Lord, is that the person who is holding the judicial proceeding is not necessary party. He has no right in law to defend his own order. He has no right to claim that he should be made party, and he is having statutory or legal right to defend his own order. So that is the second argument, my Lord. In support of this argument, my Lord, I rely on 2-3 judgments, my Lord. I have annexed the judgments with my application, my Lord. And my application, Your Lordship will find. First, I take Your Lordship to the impugn order, my Lord, at page 8. And the miscellaneous application number is? What is the application number?
Page 8.
Page 8, Your Lordship has my application.
Your compilation?
No, application, my Lord. Miscellaneous case, yes. 199, my Lord. I am seeking permission, Your Lordship, at page 5 of my application. My prayer is
page 8.
Page 5 is my prayer, my Lord, to delete or remove respond number 2 from array of parties, my Lord. 1 and 2 are Lokayukta and his officer. Then page 8 is the order, my Lord. Order of 26 February 2021, my Lord. Third paragraph, my Lord.
Yes.
The following facts are material for consideration of this matter. Respond number 2 to 15 are contractors. They, being not government servant, do not come under the jurisdiction of Meghalaya Lokayukta Act 2014. Lokayukta can exercise jurisdiction only over respond number 16 to 18 who are government servant, my Lord.
Yes.
So Lokayukta, learned Lokayukta, my Lord, in his order, in unequivocal and clear terms and in consonance with the provisions of the Act, holds that Lokayukta has no jurisdiction over private persons, private contractors. After holding this, my Lord, if you have jurisdiction, then only you can exercise power. If you do not have jurisdiction, you can't exercise power. Now, after holding that, then the last paragraph of the order, my Lord, of page 9, Lordship direction has been issued. Due to lack of jurisdiction over non-government servants, persons like contractors, as page 9, my Lord,
Yes.
last. Due to lack of jurisdiction over non-government servants, persons like the contractors, as mentioned earlier, and other legal hurdles in greater interest of public and for doing justice, it is directed that. Now,
Yes.
due to lack of jurisdiction, and now Lokayukta is exercising the power of constitutional court, my Lord, or the courts under CRPC, when it says that person like contractor it is greater interest of public, and for doing so, it is directed that complaint petition be treated as and registered as FIR under provisions of section of law by local police under the supervision of additional SP William Nagar. Who will supervise what? Who will do it, my lord? The persons against whom prima facie case of misuse of misappropriation is brought to book and prosecuted in accordance with the provisions under the Code of Criminal Procedure, punished under IPC and appropriate. DGP Meghalaya shall monitor the entire criminal proceeding. SP Williams shall inform the registry about the initiation of within 10 days from the receipt of this order, my lord. So this order, my lord, in my humble submission, my lord, could not have been passed by Lokayukta because Lokayukta has no jurisdiction against the private contractors. Lokayukta will be a private person like me.
But this will be the issue in the main case.
This will be the issue in the main case. The purpose of showing this order is, my lord, that Lokayukta has exercised this power under Lokayukta Act. Though Lokayukta has said that it has no jurisdiction, but it is under the Act only. Now, on the basis of the complaint filed by the client of Mr. Sam. So, what I was trying to impress, my lord, that Lokayukta has passed the order, right or wrong order, that your lordship will judge it in a judicial capacity. 1920, the section has shown that it is a judicial proceeding, my lord. In judicial proceeding, this order has been passed, my lord, and then, my lord, therefore, Lokayukta could not and should not have said that I am necessary party and I should be heard in defending this order, my lord. And therefore, Lokayukta should have said, all right, state is not inclined to make me party. I bow down and go out, but Lokayukta is having some interest, I don't know, which my friend will elucidate it. Now, my lord, kindly see the judgment which I have annexed with my application, my lord, at page 10. In that case, Lokayukta challenged the decision. Page 10 of the application, my lord. Page 10 of the same application. Page 10, my lord.
Yes.
In this case, my lord,
Yes. Please.
the petitioner is in this case, my lord, Lokayukta challenged the decision of state government refusing to grant sanction, and that decision was challenged by the inquiry wing of Lokayukta, my lord. And kindly see page 11 of the judgment rendered by division bench headed by Chief Justice of Madhya Pradesh High Court, my lord. The petitioner is Special Police Establishment Indore, namely Office of Lokayukta, State of Madhya Pradesh. The case of the petitioner is that on report made to the petitioner that respondent number 4 has amassed property and asset beyond known source of income, a raid was conducted at his premises. Consequently, a FIR was registered in crime number so and so. Report was accordingly prepared. It was submitted before sanctioning authorities seeking sanction to prosecute respondent number 4. Respondent number 3 by impugned order has rejected the grant of sanction to prosecute, and respondent 3 prosecute. Respondent 4 questioning the same instant petition is filed. Sri Vineet Kumar Jain, learned senior counsel, appearing for petitioner counsel, contend the state have committed an error in refusing to grant sanction to prosecute the respondent number 4. Substantial material exists, my lord. I leave aside the
Just go to the relevant.
Yes, my lord. Then your lordship will see paragraph 7, my lord. 7, where the issue is there, my lord. Paragraph 15. In the instant case,
Yes.
page 15, paragraph 7, my lord.
Yes.
In the instant case, the question that would arise
Yes.
for consideration is as to whether Lokayukta as an institution has any authority to challenge an order refusing to grant sanction by state. Because, my lord, the direction, for example, my lord, direction has been issued to the state to register the FIR in this case. State refuses to register the FIR on the ground that it is beyond the jurisdiction, my lord. Whether Lokayukta can come and challenge the decision of the state, stating that the decision of the state government in not registering the FIR despite direction is illegal, erroneous. Somewhat facts are similar, my lord, in my humble submission. In the instant case, the question that would arise for consideration is as to whether, as an institution, has an authority to challenge an order for refusing to grant sanction. As held here and above, the said question has already been answered by judgment in so and so. Every state body has a role to perform, my lord. Kindly mark this line. It has to do within the confines of power vested in it by statute. Lokayukta has a role to play as much as state government has its role to perform. Duty of Lokayukta is to conduct investigation, thereafter placed for grant of sanction. Otherwise, government in turn has responsibility to go through the material and thereafter to come to conclusion as to whether sanction is to be granted. Grant of sanction is very important facet in matter of prosecution of civil service. It is intended to ensure that there are no frivolous prosecution that carried on. It is for the reason that question of grant of sanction becomes. Therefore, once Lokayukta has performed its duty of submitting its report to government, its role ends, my lord. Because here also I say once it is the discretion of the government to grant sanction or not, when such sanction has been refused, could not challenge the said order. So this was the precise question whether Lokayukta as an institution, paragraph 7, my lord, could have challenged the decision of state government refusing to grant sanction or not. What High Court says that Lokayukta has certain role. Its role ends up within the confine of the act, and the precise language or word used is used, my lord. Every institution or every authority has certain role under the act. We are all governed by rule of law, my lord, and rule of law is that law is supreme, not my individual. Law, if law gives you right to take the matter further, you can do it, but here you are a judicial body, you cannot do it, my lord. That is what, and there are two recent judgments of the Supreme Court on this issue, my lord, dealing with this aspect, my lord. First judgment is, my lord, of 2023 SSC Online SCs 1613, my lord.
Yes,
Paragraph 3, my lord. First paragraph 3. The appellants have challenged the order passed by the High Court, whereby writ petition filed against the order passed by Lokayukta in the complaint filed by respondent number was dismissed. Briefly, the facts available on records are respondent number 1 filed a complaint with Lokayukta narrating long history of revenue records pertaining to land, my lord. Then, my lord, it was relating to revenue records, my lord. Paragraph facts are there and certain directions came to be issued by Lokayukta, my lord. Paragraph 5, my lord, at the learned counsel for the appellant submitted that the order passed by Lokayukta was totally without jurisdiction, while it issued positive direction for correction of revenue record and also to receive tax for statutory have been prescribed under 1961. Then, my lord, paragraph 9, my lord, the other judgments of the High Court has been referred to and relied upon by the Honorable Supreme Court in paragraph 9. In fact, your lordship will see the first line of the page, on the second page. Lokayukta is not a supervisory body above statutory authorities in hierarchy under the aforesaid statutes. The jurisdiction given to Lokayukta is only to address the issue of maladministration, however, without addressing that order travelled beyond jurisdiction to deal with the matter on merits and issued positive directions, my lord. After dealing with all the judgments, my lord, the Honorable Supreme Court, my lord, paragraph 11, my lord. In our view, in the aforesaid two judgments of the High Court, the provisions of 1990 Act were rightly interpreted. However, in the case in hand, direction was issued by Lokayukta for correction of revenue records was upheld, which goes totally beyond the jurisdiction of Lokayukta. So what I say, my lord, it is totally beyond the jurisdiction of Lokayukta to defend its own decision. Lokayukta has to act within the confines of law, my lord. Law is that when complaint comes to you, you will adjudicate and pass order within the confines of law. If you do it beyond the confines of law, those orders will be nullity and those orders will be set aside, and the Honorable Supreme Court in this case, where the direction was issued for correcting the revenue record. In my case, direction has been issued to register the FIR.
Mr. Kumar, you are, advancing argument on the merits of the.
Yes, no, what I'm trying to say, my lord, for two reasons, because there is some overlapping of merit, my lord. Because what I have to show is that it is a judicial decision, my lord. A. B. I have to show that Lokayukta has travelled beyond the jurisdiction. C. Lokayukta has no jurisdiction to defend its own order when it is beyond jurisdiction. For that purpose, my lord, for limited purpose,
that is precisely the issue that we are.
Yes, my lord. This is the, and then second judgment, my lord, is by, my lord, the issue is, my lord, tribunal was not made party in this case. This is a judgment rendered by, my lord, 3 judges headed by the present Chief Justice, my lord. And in this case, my lord, if your lordship will see and tribunal was not made party, High Court dismissed the writ petition on the ground that tribunal was not made party and writ of certiorari cannot lie without making the tribunal party, my lord. That was the High Court full bench decision. That has been reversed, my lord, in this judgment, my lord. A division bench of the High Court of Gujarat dismissed a later patent appeal filed by the appellant. Paragraph 1, my lord. I'm sorry, I'm reading the paragraph 1, my lord, at second page, my lord.
Yes, please.
A division bench of the High Court of Gujarat dismissed a later patent appeal filed by appellant. LPA arose out of dismissal of a special civil application under Article 226 and 227 of the Constitution by learned single judge on the ground that it was not maintainable. In arriving at this conclusion, division bench relied upon judgment rendered by 5-judge bench of Gujarat of the High Court of Gujarat, High Court in Gujarat in SRTC, in which it was held that in a special civil application under 226 and 227 of the Constitution is not maintainable, where the court or tribunal whose order is sought to be quashed is not implicated as party to the proceeding. The appellant assessed the judgment of division bench. My lord, paragraph 3. The facts have been noted, my lord, briefly. Instituted a civil application before the High Court besides seeking challenge tribunal, punishment of dismissal, etc. May now kindly see paragraph 6, my lord.
Yes.
The issue whether a tribunal or court whose order is challenged in the proceeding under 226 and 227 of the Constitution is a necessary party to the proceeding has been considered in a judgment of this court in so and so versus State of Gujarat. The judgment of this court has also adverted to the view that has been taken by judgment rendered by judge of 5 bench in Gujarat noted above. After considering the position of law emanating from the earlier decision, the judgment holds as under. Now, therefore, the proposition that can safely be culled out is that authorities or tribunal who in law are entitled to defend the orders passed by them are necessary parties, and if they are not arrayed as party to writ petition can be treated as to be not maintainable, or the court may grant liberty to implead them as party in exercise of discretion. There are tribunals which are not at all required to defend their own decision, and in that case such a tribunal need not be arrayed as parties. The purpose of showing, my lord, the entire act was that the Lokayukta is not required to defend its own decision, and therefore they are not necessary to be arrayed as party. After holding all this, my lord, paragraph 9.
Yes.
The tribunal is not required to defend its order when they are challenged before the High Court in a special civil application under 226 and 227. The list is between management and a member of a teaching or non-teaching staff as the case may be. It is for the person aggrieved to pursue his or her remedies before the tribunal. An order of tribunal is capable of being tested in exercise of power under review under 226 and 227. When the remedy is invoked, tribunal is not required to step into the arena of conflict for defending its order. Hence, tribunal is not necessary party to the proceeding in a special civil application. So my entire argument, my lord, is based on two propositions primarily. One, my lord, that I am a dominus litis, my lord, and the Lokayukta is not necessary or proper party in Article 226, 227, Petition 5. Second proposition is, my lord, that Lokayukta is exercising judicial power and it has no business to come and act on behalf of the private complainant. Private complainant is before your lordship. And private complainant can defend the order of Lokayukta. If this particular proposition is accepted, that Lokayukta is a necessary party or quasi-judicial authorities are necessary parties, my lord, in all writ petitions filed under 226 and 227, they will be required to be made party mandatorily before this honorable court, failing which petition will not be maintainable. So therefore, what my friend is trying to argue or will place his case is that Lokayukta is a necessary party. Lokayukta has vested interest in defending its judicial order. And in my humble submission, my lord, that will not lay down the correct proposition of law. Lokayukta is a judicial body and it can leave the matter to be defended by the private complainant. Therefore, in my humble submission, my lord, I pray that permit me to remove Lokayukta from array of parties.
Yes. Lordship, if I can humbly point out, item number 5 before my lord today, the petitioner in that case has filed a similar petition. Petitioner is also present before my lord. If he has any additional submissions, I can address both sets of submissions at the same time.
Look, this application, my lord, we'll rely on what the application. Only I want to point out, my lord, that when the matter was moved, item 5, all these submissions which have been advanced by learned advocate general now have also been recorded by then Honorable Justice More, and the impugn order has been stayed until further order. And the entire issue of the Lokayukta not having the jurisdiction to pass that order has been spelled out in the order. Lordship may just go to the order of 25th of March 2021, item 5.
You are a complainant.
I am the respondent against whom the direction has been.
Okay.
The first order, 25th of March 2021.
I can't read from that part. Please.
Also, you kindly see, my purpose is only to show the conduct and why the Lokayukta is having some interest in this matter to try to defend. Lordship, you kindly see the order, my lord, paragraph 2, the second subparagraph at the first page.
Yes.
On 23/6/2020, responding to Lokayukta issued ex parte order directing the DGP Meghalaya to cause preliminary inquiry. My learned senior advocate general has read out the provision by which preliminary inquiry is supposed to be directed for, and it could not have been done ex parte, my lord. And that too directing the DGP to cause inquiry and to submit a report within 4 weeks from the date of the order. The Lokayukta was also pleased to issue notice to all the respondents and the GHDC in the complaint case
Further notice was also issued to Chief Secretary so and so to see that no further payment against pending bill, if any, in connection with the scheme's work in question is made without prior leave of the Lokayukta. At the very instance, my lord, Lokayukta thought it fit to pass an ex parte order before the inquiry to withhold the district council from making any payments without the leave of the Lokayukta. That also must be entirely without jurisdiction. Thereafter, Lordship will kindly see the next paragraph. On 30/7/2020,
Yes.
complaint case 5 of 2020, which is the case filed by the complainant, was placed before the Lokayukta in pursuant to an application filed by the petitioner before the Lokayukta. By the said application, petitioner requested the change of the inquiry officer. His application was not entertained on the ground that preliminary inquiry has been completed and a report has also been submitted. However, the inquiry officer was directed to go ahead with the detailed inquiry as proposed by him. He was also directed to associate two independent leading persons of the locality during spot visit, so and so forth. In paragraph 4, pursuant to the above report and directions of the Lokayukta, inquiry was conducted by the inquiry officer and report was submitted to the Lokayukta on 16/10/2020, copy of which is annexed at page 75. The inquiry officer concluded that there is no evidence on record to substantiate the allegations made in the petition before Lokayukta that there was rampant corruption and misappropriation of public funds by the contractors and officials of GHADC in execution of the works projects under William Nagar constituency. The inquiry report further shows that all the projects undertaken by the respondents before the Lokayukta have already been completed. Thereafter, my lord will see, after the report, the Lokayukta has adjudicated on the issue. The complaint case number 5 of 2020 thereafter was placed before the Lokayukta on 26th February 2021. On that day, after hearing learned counsel for the respective parties, various directions were issued by the Lokayukta, including a direction that the complaint petition be treated as and registered as an FIR under proper section of law and investigated by local police under the supervision of Additional SP William Nagar. Petitioner being aggrieved by this direction approached this court invoking the articles of 226 of the Constitution of India. Now, my lord will kindly see para 8.
Yes.
At this stage, references must also be made to the order of the division bench of this court, which is referred above, under which it is held that a body to be called the Lokayukta, as specifically stated under section 3 of the Meghalaya Lokayukta Act, is not in existence. The impugned directions are issued even after the inquiry officer found that there is no corruption or misappropriation of public funds by the contractors and officials of GHDC in execution of the projects. The directions seem to have been issued while spending the funds. Strict adherence to guidelines issued by the Niti Aayog were not followed. However, in this regard, there was no reference to the inquiry officer. So my only point to show this, my lord, is that the Lokayukta right from the very beginning seems to have had some vested interest. First, they have directed for an ex parte inquiry, then they have asked them to stop the fund, then they have asked the petitioner, the complainant, has filed to change the inquiry officer. That was not allowed. The inquiry report found that there was no case, nothing made out, all the projects were completed. Despite that, the Lokayukta has directed for a further investigation. After the investigation also, my lord, it was found that there was no material to substantiate the allegations and moreover did not have jurisdiction. Yet, my lord, these directions have been passed and now they are trying to defend it, my lord. That is my humble submission, my lord.
Again, Mr. Deb, you are going to the merits of the...
It's only to show, my lord, that the Lokayukta has adjudicated on the matter. Between the issue was, my lord, that between me and the client of my learned senior, Mr. Sangma, he has filed a complaint against me, saying that I have not completed the work. The role of the Lokayukta is only to see, on a prima facie basis, whether the allegation is correct or not. It is not to put its own views, my lord, that this is not followed, that is not followed, maybe Niti Aayog is not followed, maybe inquiry was not proper. All these show, my lord, that even otherwise the Lokayukta has adjudicated on the matter, taken a quasi-judicial decision to direct.
Yes, I think in the order that you have just read, reference was made that the Lokayukta has a directive for investigation and all those things.
Lordship, and after hearing, they have gone through the entire material. It is wrong to say, my lord, that they have not adjudicated. They have adjudicated and they have passed the impugned order under the, my lord, the provisions of the Lokayukta Act, which say that these are the proceedings deemed to be under the IPC. And as such, my lord, it is a judicial or quasi-judicial order, and that being so, my lord, it is for the complainant to otherwise show that this order has jurisdiction.
Yes, so that's it.
Lordship, and as far as I am concerned, my lord, I am the contractor, private contractor, and the state is, my lord, concurring to the submissions made that the order was passed without jurisdiction.
But as far as this case is concerned, this is posted for hearing, isn't it?
This fix, no, that is item 1.
No, we're talking about item number 5.
Yes, 5 has already been posted for hearing, and the order has.
So
been so we have filed a
there is no issue of questioning the
no, that is also
jurisdiction of the Lokayukta here.
That would be, my lord, Miss Case 208, which is there today. It's an analogous application.
Okay. This case.
Miss Case 208. Similar points and similar replies.
Yes.
Me, please, Your Lordship. Lordship, my job before this honourable court today is a very easy one, my lord. It has been made easy by the Honourable Supreme Court, because just a few months back, Honourable Supreme Court took the trouble of pronouncing a judgment where, in so many words, Honourable Supreme Court has said Lokayukta has to be heard. Lokayukta, you have to make Lokayukta a party in such proceedings. So the matter is settled. But before placing the judgment, there are many incidental submissions which have been advanced, which I'll need to address, my lord, with lordship's permission. 2 sets of submissions have been advanced by the 2 petitioners, my lord. I'll deal with possibly the easier of the 2 sets, that is the submissions in item number 5 by my learned friend on the side. Item number 5, my lord, the petitioner, lordship himself, I am confident, has noticed 99% of his submissions were on the merits. He read out order dated 25th March 2021 passed by this honourable court at the time of admitting item number 5. Order dated 25th March, my lord, records the merits of the matter as to whether or not Lokayukta was right, etc., my lord. That is on the merits. That will come later once this issue is traversed, my lord, the issue of my locus to address this honourable court. The only other submission that was made by petitioner in item number 5, and I will not call it a submission, it was an innuendo, my lord. An innuendo was passed that it seems that Lokayukta has some vested interest. Lordship, I'm again confident, my lord. I don't need to address innuendos which are passed brazenly in open court without material, without substance, my lord. So that is as far as item number 5 is concerned, my lord. Now in item number 1, 2 broad submissions have been raised. 2 broad submissions have been advanced to justify their miscase number 199, where they have asked for me to be deleted, respondent number 1 and 2 to be deleted as a party in this case, my lord. 2 broad contentions have been raised. First contention, my lord, is that according to petitioner is the dominus litis of these proceedings, the master of the suit, and therefore it follows it is the prerogative of the petitioner to choose who to make a party, who not to make a party. Lordship, I cannot dispute the fact that petitioner is the dominus litis. In any case, not just this case, petitioner is definitely the master of the suit, my lord. But being the master of the suit does not equal to having been granted a carte blanche, an open license to do anything that comes to mind. Any action of the dominus litis, either in terms of impleading or non-impleading a party, has to be in accordance with law. So therefore, if law requires you to implead a certain person, you are required to implead that certain person. If that person is a necessary party, you are required to implead him as a necessary party. The defense cannot be, I am the dominus litis, and therefore I will not implead. So
but in due course.
Yes, my lord.
You see,
Yes, my lord.
in due course, the success and failure
Yes, my lord.
of the stand of the petitioner
Yes, my lord.
therein
Yes, my lord.
would be a a matter of
Absolutely.
argument.
Absolutely. Absolutely.
Or findings of the court for that.
Absolutely, my lord. Absolutely, my lord. So, but we are still at the initial stage of this particular matter. We have not yet gone to the final adjudicatory stage of conducting a hearing on merits, my lord. At this stage, the issue has been raised that a party that petitioner has impleaded, maybe by mistake, is not a necessary party and therefore should be deleted. My submission, my response, so my very humble response, my lord, is that dominus litis does not cloak the petitioner with an open license to do as in what petitioner may want. Any action, any decision of the petitioner has to be in accordance with law, my lord. In this particular matter, I will substantiate how I am a necessary party and therefore I was well impleaded. I was correctly impleaded as a party in this case, my lord. Number one. Number two, my lord, the submission has been advanced that I am a judicial body, I am a quasi-judicial body, etc. And therefore, I cannot be heard by this honorable court because a judge will not stand before an appellate sort of supervisory or appellate authority and defend his own order. Before addressing that, I am required to point out one very interesting aspect of this matter. This is connected to that first dominus litis issue only. Lordship, the writ petition in item number 1, when it was filed originally, there were only two respondents, me. I was respondent 1 and 2. There was no other respondent. So writ petition was filed, and I stress on this, this is a writ petition, man. This is not a 227 petition, this is a 226 petition. Today they are saying that I am not a required party, I am not a necessary party. If I am not present in this matter, first point is, how does a writ petition lie? So their argument that you are not a necessary party, I am a state instrumentality, I am other authority under Article 12. If their argument is agreed to, that I am not a necessary party, that is a self-destructive argument, my lord. Because if honorable court agrees I am not a necessary party, there is no one left to exercise writ jurisdiction against. Lordship will not exercise writ jurisdiction against a private individual. That is respondent number 3. So maybe the fault is mine, but I fail to understand that if I am thrown out of these proceedings, the other authority is thrown out of these proceedings, how does the writ survive, my lord? Writ does not survive, my lord.
So it has to be in the form of a revision, you mean?
I will not dare to suggest anything of that sort, my lord. I will not, it is not within my competence to make a suggestion to the state in that respect. But I can only point out what is the position as on date.
It may lead to that conclusion. Anyway, that's
I cannot say anything on that, my lord. That is one aspect. Second aspect, more interestingly, my lord, as I said, I was the only impleaded party. If lordship looks at order dated 6/12/2021, item 1. 6/12/2021. Six 2021.
Six or 16?
6. Oh, so, I apologize, my lord. 16. I apologize. 16. Sorry.
Yes.
16/12/2021. This order will reflect, my lord, on that day I entered appearance, respondent 1 and 2, first paragraph. Second paragraph, it is also brought to the notice of this court that and this is what I brought to the notice of this honorable court, that the complainant has not been arrayed as party respondent. Mr. A. Kumar, learned AG, accordingly praised that he may be allowed to file appropriate application for impleadment, etc. So, on the day I entered appearance, prior to that, on the date of institution of the writ petition, complainant was not a party. So, on the day they filed the writ petition, petitioner was clear in petitioner's mind that I am the only required party against whom the writ petition needs to be filed. Only when it was pointed out by me that complainant against whom, on whose basis the entire proceedings started before the Lokayukta, he is not a party, complainant has been arrayed as a party. So after having arrayed me consciously as a party, what do the petitioners state in their present miscase, my lord? Para 4 of the miscase that they have filed, my lord. That is at page 4, miscase 199.
Yes.
Para 4, that it is submitted that inadvertently the chairperson so and so have been arrayed as respondent numbers 1 and 2 to the writ petition. I was the only respondent.
Yes.
And now they say it was a mistake to array me as a party, my lord. That cannot stand, my lord. So this is regarding the first point of dominus litis, my lord. That they were the masters of the suit. Definitely they are, but that does not give them an open license, my lord. The second point which has been contended, which has been placed, is that I, according to petitioner, am a judicial or a quasi-judicial authority. Now, various provisions of the Lokayukta Act have been taken through by Learned Advocate General to try and substantiate how I am a judicial or quasi-judicial authority. Again, fault may be mine, but beyond being a refresher course in the provisions of the Lokayukta Act, I did not see as to how they substantiated that I am a quasi-judicial or a judicial authority. The only place in the Lokayukta Act where I have been referred to as a quasi-judicial or a judicial authority is in section 27. But that, my lord, is in a very, very specific context. If lordship kindly looks at section 27 of the Act.
Yes.
Section 27, my lord. I'll read, my lord.
Yes.
Section 27(1). 27(1).
Yes.
Section 27(1), my lord. Subject to the provisions of this section, I'll read this slowly, my lord. Subject to the provisions of this section, for the purpose of any preliminary inquiry, the inquiry wing of the Lokayukta shall have all the powers of a civil court under the Code of Civil Procedure, so and so, so and so, so and so. What I'm highlighting, my lord, is that the Lokayukta, the institution of Lokayukta, has not been clothed or vested with the powers of a civil court. It is only a component, and the Lokayukta consists of inquiry wing, prosecution wing, administration wing, various parts are there. It is only the inquiry wing, and only when conducting a preliminary inquiry, they have been vested with the powers of a civil court. It is not the institution of the Lokayukta that has been vested with the powers of a civil court. So to read this in a holistic manner and to state that Lokayukta has the powers of a civil court, my lord, that may not be entirely correct, because it is a very specific power given to a very specific portion of the Lokayukta and only during a very specific period of time. During preliminary inquiry, the inquiry wing shall have the powers of a civil court. That does not mean the Lokayukta is a judicial body, my lord. That cannot be the inference of this provision. Subsection 2, my lord, of the same section. Any proceeding before the Lokayukta shall be deemed to be a judicial proceeding within the meaning of section 193 of the Indian Penal Code. It is a judicial proceeding only as far as section 193 of the IPC is concerned. It is not a judicial proceeding per se. So section 193 IPC, my lord, is already well aware. This is a very common provision in a lot of acts, my lord. It's a very common provision in a lot of acts. This is regarding giving false evidence, my lord. So if you appear before the Lokayukta and give false evidence about any matter, then you can be proceeded with under section 193. Does that mean the Lokayukta is a judicial body conducting judicial proceedings? No. It is, the proceedings are judicial proceedings only when a person gives false evidence and when action is to be taken against that person. In that situation, Lokayukta is vested with the powers of a judicial authority under 193. To extrapolate that and to say that entire institution of Lokayukta is a judicial body, my lord, again, with respect, that will not be the correct approach, my lord. So 27, as I said, is the only portion, or is the only part in the Lokayukta Act where some reference is there, but the reference is in a very limited context for a very limited purpose, my lord. Secondly, what I will request this Honorable Commission to kindly appreciate is something very important. The Lokayukta, my lord, does not adjudicate anything. If I am allowed to explain, what does the Lokayukta do? Section 20 may kindly be looked at. And my learned senior had taken the pain of taking my lord through most of this, and this is the procedure before the Lokayukta, my lord.
Yes.
Now, section 20, there is a very comprehensive procedure. If I can just sum up the procedure, complaint is filed.
Yes.
Complaint is filed. Complaint is processed. Preliminary inquiry is called for. Preliminary inquiry report is submitted. Lokayukta applies its mind. If comes to the conclusion that there is a prima facie case made out, then detailed inquiry is called for. Detailed inquiry report is submitted. Then again Lokayukta applies its mind as to the findings of that detailed inquiry. Once the detailed inquiry has been examined, then subsection 7 comes in, my lord. If Lordship looks at subsection 7. So up till that stage, up till the detailed inquiry submission stage, nothing has happened, no adjudication. Lokayukta has not said anything on the merits of the case. Subsection 7. A bench consisting of not less than 3 members, now it is 1 member, my lord.
Yes.
A bench consisting of not less than so and so of the Lokayukta shall consider every report, that is the final report, received by it under subsection 6 from any investigation agency, including any special agency, and may decide as to A. File charge sheet or closure report before the special court. B. Initiate the departmental proceedings or any other appropriate action against the concerned public servants by the competent authority. So what happens? Detailed report comes to the Lokayukta. Lokayukta studies the report and recommends some action, if there is some case made out. Recommends filing of charge sheet in the special court. Special court will proceed with the matter. Special court may or may not prosecute that person, punish that person. Prosecution is not done by me. Punishment is not awarded by me. Similarly, I recommend initiation of departmental proceedings by the competent authority. So I do not decide anyone's fate, my lord. I have the power of recommendation. Only the power of recommendation. Will that make me a judicial body? No. Will that make me even a quasi-judicial authority? No, my lord. And this is something that was touched upon by a judgment which learned AG had submitted, the 2023 judgment, Supreme Court judgment, my lord. Additional Tehsildar.
Yes.
Para 9 of this judgment.
Para 9.
Para 9, my lord. And this is just a reference made by the Supreme Court, but it has a bearing on what I was saying, my lord. Para 9, my lord, I'll read.
Yes.
Insofar as the jurisdiction of Lokayukta is concerned, the division bench of the High Court in so-and-so versus so-and-so opined that in terms of Section 12(1) of the 1999 Act, Lokayukta was not competent to issue positive direction. He can only submit a report with the concerned authority with its recommendations. They only have recommendatory jurisdiction. So therefore, if that is the case as observed by Supreme Court, I am not adjudicating anything. I am not, as I said, to use casual language, I am not deciding anybody's fate. So how can I be termed as a judicial or a quasi-judicial authority, my lord. Lastly, my lord, reference to buttress this contention that I am a judicial, quasi-judicial authority, therefore I have no right to defend my own order. Reference was made to the MP High Court judgment, my lord. That is in the petition itself, that is Miss Case 199.
Yes.
Now this judgment was referred page 10 of the Miss Case. Page 10, my lord. This judgment was referred, my lord, to try and impress upon this honorable court that according to the Honorable Madhya Pradesh High Court, once the Lokayukta passes an order, the Lokayukta has no more business to be concerned with that order and has no right to challenge or take further part. In other words, Lokayukta becomes something like a functus officio.
Yes.
But as always, my lord, with lordship's permission, I will read the judgment slowly, my lord, because the context is important. In what context was the judgment passed? The context, my lord, comes out in the first paragraph of this judgment at page 11 itself, my lord. And it is the context which decides, which sheds proper light on this judgment, my lord. I'll read, my lord, para 1. Petitioner is the Special Police Establishment, Indore, namely the Office of Lokayukt, State of Madhya Pradesh. The case of the petitioner is that, on a report made to the petitioner that the respondent number 4 had amassed properties and assets beyond the known source of income, a raid was conducted at his premises. Consequently, an FIR was registered in crime number so-and-so. A report was accordingly prepared. It was submitted before the sanctioning authorities seeking sanction to prosecute respondent number 4. The respondent number 3, by the impugned order, has rejected the grant of sanction to prosecute respondent number 4. Questioning the same, the instant petition is filed. I'll pause. So what has happened here? FIR was filed, some report was generated, report was placed before the competent authority of the state government seeking sanction. Respondent number 3 in this case refused the sanction. It is against the refusal, Honorable MP High Court was approached by whom, my lord? By the Lokayukta himself. That is at page 10. It is obvious from the cause title. Lokayukta himself has challenged the non-grant of sanction. Lordship sees the petitioner, Special Police Establishment through so-and-so, 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 aged about so-and-so, Lokayukt Office, Indore, Madhya Pradesh.
No, but I think the petitioner is the Special Police Establishment.
Yes, my lord, because in Madhya Pradesh, in Madhya Pradesh, my lord, Lokayukta has its own police department, yes, police branch also.
As elsewhere.
Yes, my lord. So it is the Lokayukta police. That means the office of the Lokayukta who has challenged. If lordship takes the trouble of reading
I think if I
yes,
correctly recall,
yes,
the Lokayukta has 2 wings.
Inquiry
wing and
prosecution wing. There is no police, like in Meghalaya, for example, my lord, there is no police department. There is no executing arm of the Lokayukta in Meghalaya. MP is different, my lord. Some other states are there, MP included, where they have their own executing arm in the form of police personnel. So it is that policeman who maybe he's the IO of the case, my lord.
And in this case, the report was filed before the Special Police Establishment and not before the local.
No, the first line, my lord. Petitioner is the Special Police Establishment so and so. Yes. Case of the petitioner is that on a report made to the police, the police wing, police establishment.
That's what it is.
Yes, ma'am. So it is the police. So what happens in MP? Instead, if I have a complaint to file with the Lokayukta, instead of filing in the office of the Lokayukta, I file maybe an FIR or a complaint with the police department of the Lokayukta. Police department investigates, etc. Then matter proceeds as per their own rules, my lord. So slightly different from our state because we don't have a dedicated police wing, police department connected to the Lokayukta. So complaints come directly to the Lokayukta, my lord. So that, in my very humble submission, would not really make much of a difference. Point here being that against what had the petition been filed, it was filed by the office of the Lokayukta through the police department of that Lokayukta, against the non-grant of sanction. Now, it is in that limited, in that very specific context that the Honorable MP High Court said what it said in in para 7. Now, para 7, I'll skip the first part. I'll just go to the next page, my lord, page 16, second line onwards, my lord.
Yes. Yes.
I'll read. The duty of the Lokayukt is to conduct an investigation and thereafter to place it for grant of sanction or otherwise to the government. The government, in turn, has the responsibility to go through the material and thereafter to come to a conclusion as to whether any sanction is to be granted or not. The grant of sanction is a very important facet in the matter of prosecution of civil servants. It is intended to ensure that there are no frivolous prosecutions that are carried out. It is for this reason that the question of grant of sanction becomes crucial. Therefore, once the Lokayukta has performed its duty of submitting its report to the government, its role ends. Its role ends as far as that sanction aspect is concerned, my lord. Its role ends. It is the discretion of the government to grant sanction or not. When such a sanction has been refused, the Lokayukta could not challenge the said order. So it is the discretion of the government whether or not to grant sanction in that limited context, very specific context. MP High Court said, Lokayukta cannot challenge that discretion. It is the discretion of the government to grant or not to grant sanction. Once you have asked for sanction, then your role ends. If it is not granted, you cannot challenge that non-grant of the sanction. This is not an empirical or a universal proposition of law that in each and every case, Lokayukta cannot defend its own order or should not even attempt to defend its own order, etc. Supreme Court has made that very clear, my lord, just some time back. If I'm allowed to place this judgment, my lord. Lordship, this is from 2023.
Yes.
And this is with specific reference, unlike educational tribunals, etc., which were referred in other judgments. This is with reference to Lokayukta. So 2023, just some time back, my lord. Now, again here, the parties are important. Who's the party? If Lordship sees the cause title, office, first page, my lord, cause title, Office of the Odisha Lokayukta is the appellant who has gone before the Supreme Court. In this case, what happened, my lord? Complaint filed with the Lokayukta. Lokayukta issued an order for preliminary inquiry. That order for preliminary inquiry was challenged in the Honorable High Court of Odisha. Without hearing the Lokayukta, that order was set aside. Lokayukta's order was set aside. Lokayukta appealed that order before the Supreme Court, saying that I should have been heard. It is in that context that this judgment has been passed. If I'm allowed to read certain portions, my lord, para 25.
Yes.
Para 25, my lord. Mr. Ranjan Kumar Das, Deputy Superintendent of Police, Vigilance Cell Unit, Bhubaneswar, was not a person interested, but as an informant, submitted a complaint against respondent number 1, MLA Gopalpur constituency, to Orissa Lokayukta regarding possession of disproportionate assets and intentionally enriching himself, illicitly adopting malpractices. On the said complaint being received, the appellant, that means Lokayukta, my lord, appellant directed the Directorate of Vigilance Cuttack to conduct a preliminary inquiry against respondent number 1 in exercise of his power under section 21 of the Act 2014 by an order dated so and so. Before any action could have been taken by the Directorate of Vigilance in conducting a preliminary inquiry, a writ petition was filed by respondent number 1 before the High Court, and on the first motion stage, the High Court, without affording an opportunity of hearing to the appellant means Lokayukta, set aside the order dated so and so passed by the appellant for conducting a preliminary inquiry. The action of the division bench of the High Court indeed was in violation of the principles of natural justice. Next paragraph, my lord. I'll skip para 26, para 27, my lord. In the first instance, the division bench of the High Court has committed a manifest error in passing of the order impugned dated so-and-so while setting aside the order of the appellant Lokayukta dated so-and-so to conduct a preliminary inquiry against respondent number 1 in exercise of powers under section so-and-so of the Act, which is in violation of the principles of natural justice. Lokayukta was not heard before Lokayukta's order was interfered with. This was considered by Supreme Court to be a violation of the principles of natural justice. Even more explicit, my lord, is para 39. Here also the objection was raised, my lord. Before the Supreme Court also, objection was raised that Lokayukta has no locus. Para 39, I'll read, my lord. The further objection raised by the respondents is in reference to the locus standi of the appellant Lokayukta. In filing appeal in this court and in support of his submissions, counsel placed reliance on the judgments of this court in so-and-so versus so-and-so, MS Kazi, which Learned AG had also referred to. In our considered view, the submission is wholly bereft of merit for the reason that the action of the appellant Lokayukta, initiated pursuant to order dated so-and-so for conducting a preliminary inquiry in exercise of powers conferred under Section 21 of the Act, was a subject matter of challenge before the High Court at the instance of respondent number 1. And if that is being interfered with, and the action of the appellant is being set aside under the impugned judgment dated so-and-so, the appellant indeed, means Lokayukta indeed, was a person aggrieved and has a locus standi to question the action interfered with by the division bench of the High Court. And the only remedy available with the appellant is to question the order of the division bench of the High Court by filing a special leave petition in this court under article so-and-so. Makes it very clear, my lord. I am vested, I am clothed with necessary power to be heard before my order is interfered with, my lord. Para 42, my lord. Both the judgments, and this includes the 2016 judgment submitted by petitioner, my lord, the Kazi judgment, both the judgments relied upon are not even remotely concerned with the facts and circumstances of the present case. To say, in other words, if the order of the appellant, Lokayukta, directing the Directorate of Vigilance to conduct the preliminary inquiry in exercise of power under Section 21 of the Act, dated so-and-so, has been set aside by the High Court, obviously, the appellant is a person aggrieved and can certainly question the legality, validity of the judgment of the High Court impugned by invoking jurisdiction of this court under Article 136 of the Constitution. So, Lordship, my very humble and respectful submission before this Honorable Court is that the issue could not be more clearer, my lord. Supreme Court has taken the trouble, like I said right at the beginning, to clarify the issue. Lokayukta, my lord, has to be heard.
Do you have the copy of this 2014 Act?
It is they are referring to the 2014 Odisha Act.
Yes.
Odisha Act. Right now, I don't have it.
To have a look at this section 20.
Very well. I would assume, my lord, subject to correction, I would assume it is the same section 20. Could be, my lord. I will supply it, my lord. Right now, I don't have it. I will supply it.
If it is, parametric here.
Very well, very well. I'll supply it, my lord. By the end of day today, I'll give it to the court.
At least I will have the opportunity of seeing and assisting your lordship also, because if my friend is relying on some judgment on provisions of the Act, in rejoinder I will assist your lordship. Exactly. Because if it is supplied behind my back, then how will I get it? How will I supply? Because at the end of the day it is supplied and then I don't know anything about the matter. Judgment has been handed over to me just now.
I saw him giving it to you in your face. How do you see behind your back?
Judgment has been handed over, and I have to distinguish the judgment below. I will distinguish the judgment. I will distinguish the judgment.
Comparison of the Act would be required.
Yes, ma'am.
Please.
Right. I'm quietly confident, my lord. I don't need to take up to more of lordship's time. The issue is settled, my lord. The issue is settled. The issue raised was I do not have a right to defend my order. Supreme Court has answered that issue. I have a right to defend my order. In fact, Supreme Court has gone so far as to say I am required to defend my order, and my absence would lead to a violation of natural justice, my lord. That's all. I will supply that act.
Yes. Who else? But what is your, I think, what would be your role here?
My
This-
role
this-
here is
see,
very limited.
the prayer made in this case is not directed at you. As far as you are concerned, you have no role to play. As far as the prayer made in the case, it is only between the petitioner and the Lokayukta.
So my submission will be I will just rely with a senior that my friend who has submitted. But in fact, I should say that only some submission. I just want to make it because the learned AG is in the entire case application is questioning the correctness of the various section of the act, which means it's like amount to challenging the very act of the Lokayukta Act, which means because he has read it and he is trying to interpret and trying to questioning the correctness of the act, which means it's amount to challenging the act itself.
I did not question the act. I have not questioned the act.
He did not question the act. He was just referring to provisions in the act. and
Provision,
he-
but then he's
vis-a-vis-
trying to
vis-a-vis
interpret
the power of the
Yes.
Lokayukta.
that.
I did not challenge virus of the act.
Because that is what I observe according to my understanding, because he is saying this is the act and he's trying to interpret in a different way, which amounts to challenging that act itself, which according to me is that this court has no jurisdiction or other way. If he is challenging the act itself, then this is not in this miscase application. He has to file either the PIL or some other in a different form. And secondly, my lord. Secondly, my lord. First, as my learned friend has already pointed out, when the first initial writ petition was filed, I was not a mega party. They have made a party to the Lokayukta only. But it was only after the intervention of the Lokayukta, they implicate me as a respondent. Now they are coming and saying again that it was inadvertently, due to bona fide mistake, Lokayukta was mega party. But first instance, the case has already been admitted. They were heard without me as a private complaint. And it was only intervention, then after that only they filed an application, then I was implemented.
In any case, you see, when the merits of the case is heard or taken up, you will be given the opportunity.
Yes, then now, of course, I'm not going to under merit, but I will beg to submit, Lordship. Another thing, my original application, it is there on record. They have also enclosed in the repetition. I never make a party to the state. I make only for the private respondent. Private it is there. I never make a party to the state respondent. They were nowhere in the picture. And even the order, impugn order, was not directed against the state. Order was very clearly stated that there should be FIR against so and so. That means the private respondent, not by the state. State has nothing to do. But my learned AG always saying that what vested interest that Lokayukta has. But my question is that what state has the vested interest? Because the rear aggrieved, the order was very clearly the impugn order which that challenge, it is directed against the private respondent, saying that there should be an FIR against that MDC so and so, not the state. But the state has come up and filing, they challenging the very impugn order. That means what vested interest? They don't have the locus standi to file even that interest litigation. And secondly, my lord, I like to support to the argument advanced by my friend. He stated that this writ petition was filed. If the private respondent, I'm the one, only if I'm only a party, then this writ petition cannot be maintained. It could be some other petition, either revision or some other way, not in this way. If they are challenging the order, it should be an appeal or some other way, not this. Because I'm not a government. How can the writ petition will be maintainable? That is what my late learned friend has already elaborated, and his submission is very well. He has made a very clear submission on this. And section 28, section 20, subsection 8, 9, and 20, subsection 3, 7, A, B, C, that is very clear. I don't want to repeat it because there it speaks of inquiry, preliminary inquiry, and filing of charge sheet to the special court is very clearly is mentioned. Lokayuta, after investigating into the matter, preliminary inquiry, when the preliminary inquiry is submitted by the IO, then equal opportunity was given to all the parties. They will file a show cause, they will file a reply, and if found prima facie, Lokayuta will direct for detailed investigation. Thereafter, IO will submit a detailed investigation. After finding the detailed investigation, if found prima facie, Lokayuta has, as my learned friend has submitted, did not adjudicate, but he will file a charge sheet as per the rule. He will submit it to the special court. Then special court will try the case, and he will take the evidence and so on and so forth. So the section is very clear. My learned friend, I don't want to repeat. He has already really said that the power of the civil court that tried that is not given to the investigator to the Lokayuta. He is only an investigation agency. They will investigate the matter. If found prima facie, refer to the court. It is the duty of the special court will try. And my learned AG also is saying that complaint is limited to the public servant, but the section 14, subsection N, it is very clear that there is any, it is not necessary that person should be a public servant, but the money which is the financed by the government. Financed by the government, that is stated very clearly. This part, Lordship, I will just take you to that act itself.
Section 14.
Section 14, F, my lord. 14.1, F. If I may, I will just read it, only the portion of the act. It is there in the my learned that AG has submitted the compilation in his compilation, the page 11.
Yes.
Page 11. It says that if any person who is or has been a chairperson or member or officer of the employee of any body or all board or corporation or authority or company or society or trust or autonomous lordship, F, page 11 of his compilation, my lord. Page 11, I'm reading the F.
F.
Yes, lordship.
Okay.
F. Any person who is or has been a chairperson or member or officer or employee in any body or board or corporation or authority or company or society or trust or autonomous body or district council, bracket, by whatever name called, established by an act of parliament or of a state legislature or wholly or partially financed by the state government or controlled by it. This is very clear, which I like to stress on that one. The state legislature or wholly or partly financed by the state government or controlled by it. This is that means the contractor, because the money is paid from the government and it's a public fund. What I'm trying to, the act is what trying to convince is that the money, anything money is contributed by the government or public fund, then it's poor. They can.
So you are contradicting yourself. In the first place, you say he has no locus. Now you say yes.
No.
This is
not lordship. What I'm trying to say, maybe.
An act of the state.
What I'm trying to say is that that there is some contractor in the private complaint, and I'm saying that they're trying to say that those contractors are not a government salary. They are not for under the purview of the Lokayuta. Then the complaint cannot be filed against those private person. That is their argument. That's why I'm trying to support, because I'm saying that they are also under the preview, the complaint case can be filed against the contractor because the money has been spent from the government. That is what I'm trying to say, and that act is that is what I'm trying to say, Lordship. But I'm not insisting. But I'm trying to.
An issue of merit.
Yes, Lordship. So that is the only thing, my Lord. So I don't have much to say. Only that is the only main thing to say that. So that is my only humble submission. So maybe order maybe pass or.
I'll briefly submit, my lord, so that at least and we'll file written some note also along with our this. Lord, taking Mr. Sangma's argument first, as I have learned Q from my learned friend, Mr. Sangma has referred to section 14.4, my lord, section 14.1f, my lord. Kindly see section 14.1f at page 11 of the compilation.
See, that would be touching the merit of the...
No, only just for the purpose, my lord. I will address all those issues immediately. Mr. Sangma's 14.1f, my lord. Page is 11. Page 11. 14.1f. This is the clause relating to jurisdiction of Lokayukta, my lord.
Yes.
Subject to the other provisions of the Act, I am reading 14.1 first, my lord. The Lokayukta shall inquire or cause an inquiry to be conducted into any matter involved and arising from and connected with any allegation of corruption made in the complaint in respect of following, namely. Then your lordship will come to F, my lord. Any person who is or has been a chairperson or member or officer or employee in any body or board or corporation or authority or company or society or trust or autonomous body or district council by whatever name called, established by an act of parliament or by state legislature, wholly or partly financed by state government and controlled by it. So here, my lord, my friend is talking about the district council not established by parliament, not established by the state, because the requirement is district council has to be established by parliament or by the state legislature. District council has not been established by parliament or state legislature, it has been established by the constitution. So therefore, district council doesn't come under the purview of the act itself, my lord. If your lordship will see this 14.1f, it clearly says district council by whatever name called, established by an act of parliament or by state legislature, or wholly or partly financed by state government and controlled by. District council is not controlled by state government. District council has power under the schedule 6 and the powers are there. And paragraph 4, paragraph 3, those are powers are there. They are not controlled by, and district council has got finances through various, central government gives the finances, state government gives the finance. There is no control per se exercised by the state government on district council. So to say that the Lokayukta is meant for the state body, state like the PSU established by state, society established by state, or parliamentary by parliamentary legislation or state legislation. So the very question which my friend has raised, that Lokayukta has power and jurisdiction to go into the district council, my lord, is debated. I am leaving that question.
See, for the sake of discussion.
Yes, my lord.
This provision.
Yes. My friend has drawn my attention to.
See, your provision of 4.1f.
2.
F read with 1.
1 says, my lord.
Read with 1.
1, yes, your lordship will see.
There is some contradiction.
No, 1 says, subject to other provisions of the Act, Lokayukta shall inquire or cause an inquiry to be conducted into the matter involved in and arising connected with any allegation, corruption made in the company, in following, only in the following, my lord.
So
F is the,
also mentioned here.
so district council established by, because there can be established by act of state or parliament, my lord. District name, I can have district council established by the act of parliament, my lord, or is by, because name can be same, my lord. District council, we have got district council, but this district council is not established by an act of parliament. Requirement of it is not established by an act of state legislature.
You see, if this is with reference to the state of Meghalaya.
The state of Meghalaya is there, but this district council, my lord, is not established by any act of the state government, and it is not established by any act of parliament. It is established because this district council will be if tomorrow, my lord, the state legislature takes a decision to establish a district council separately, it will pass an act in the state legislature, and that district council will be under the purview of Lokayukta. But this district council which we have, which is established by constitution, is not established by an act of parliament. It is not established by an act of state legislature. Therefore, the question is that they are saying that Lokayukta has jurisdiction with regard to, that is very highly debatable. That issue is not there before your lordship. Therefore, I am not arguing on that part. I am coming back to the main issue, my lord. My friend has said that first argument which my friend has advanced is that 226 is not maintainable. Your lordship has correctly pointed out that the petition may have been termed as 226, but it is in essence it is 227 petition, my lord. Yes. And my friend has to that extent, in my humble submission, accepted that it is in the nature of supervisory jurisdiction by your lordship. So that because sometimes the petitions your lordship has seen is termed as 226. I can place number of authorities, but ultimately your lordship has to look into the contents, nature of prayer.
Now you are changing your stance.
No, I am not changing the stance, my lord. I am saying is, my friend is saying he is a state under Article 12. My friend is a state under Article 12, and therefore he is necessary party. But your lordship, the law on this issue is very clear, that your lordship will not go by the title of the petition or title of the application. You will lordship will see the crux of the matter, and that law. Therefore, I need not.
The dispute has to be looked into.
Yes. Therefore, I need not impress much on this aspect of the matter, my lord. This is first.
But you have to. If that would be your.
My submission is, my lord.
Your line of argument now.
My submission is, my lord, that my friend is saying, raising a technical objection, saying that it is Article 226 petition, and I am the state, and in absence of my state being party, writ petition is not maintainable. That is what I understood the argument of my friend.
If you accept that argument,
no, I do not accept.
Now you say that no, this petition has to be converted a term as one under 227.
I am 226. Your lordship, 226 and 227 have been used interchangeably in all petitions, my lord. If I will show that petition, I'll show that. I will show even in your lordship. My friend has read the judgment, this Gujarat judgment, which was relied by my friend, my lord. Kindly see in Gujarat judgment also. The petition is under 226 and 227. The Supreme Court, 226. The Gujarat judgment, Kaji, no? Your lordship will see. No, the Gujarat. Kaji judgment, my lord.
That's because the High Court rules allow it, my lord.
No, High Court rules will not override 226 and whatever is there in the Constitution will. 226 to kindly see paragraph 9.
So even the Kaji judgment has been distinguished here in this.
No, I will come to Kaji judgment, distinguishing part also, my lord. That is the I have kept it my powder dry at the end, my lord, to show that. And 9, if your lordship will see in Kaji judgment, under 226 and 227, paragraph 9. The tribunal is not required to defend its order when they are challenged before the High Court in a special civil application under 226 and 227. So I was on the limited issue of their right to remain represent to be before your lordship on 226, 227 ground. Now, what my friend is said that in the earlier there was a technical error, inadvertent error in not impleading the private respondent. That error has been corrected, my lord. The private respondent is before your lordship. So therefore, my friend cannot harp much on that aspect that earlier when writ petition was filed, Lokayukta was the only party. That issue is no longer there, my lord. With your lordship's permission, private party is before that. So that, in my humble submission, that argument cuts no eyes. It is neither here nor there, my lord, so far as this comes. Third aspect is concerned, my lord, Lokayukta, what my friend has argued is that Lokayukta is only having supervisory power. It has no judicial power. It is not a quasi-judicial body, and it only gives the recommendations, and therefore it is basically an administrative body, if I understand my friend's argument correctly. If your lordship will see the act, my lord, my friend has read paragraph section 20. Kindly see section 20. Section 20, my lord.
Yes.
21 is when complaint comes, my lord. Preliminary inquiry is conducted, my lord. I will not take your lordship again, my lord. Then the requirement of section 20 subsection 3.
Yes.
A bench consisting of not less than 3 members of Lokayukta shall consider every report received under subsection 2 from inquiry wing and agency, and after giving an opportunity of being heard to the public, decide to recommend. So there is first there will be inquiry, second the hearing will be given to the public servant below. So then they have got the trapping of judicial. If it is only recommendatory body, it's like investigating other, like police, my lord. There was no requirement of giving hearing and going into. When you have constituted a tribunal, what you do, like education tribunal, administrative tribunal, you hear and decide. When you do that, it is basically a tribunal in law, my lord. As Supreme Court judgment, I can say it is a true.
But in the light of what has been held by the Supreme Court.
I'm coming now. Lastly, because lastly, my lord, I have kept it for last, my lord, so that this judgment is in 2 minutes. I will distinguish, my lord. In 2 minutes, it won't take more than 2 minutes, my friend. 2 minutes, my lord. So what I was saying, if I succeed on this point, my lord, that it is a judicial body having a judicial power, and it has to adjudicate the matter, my lord. It has to give the hearing, my lord. And it has to give legal assistance also. Kindly see section 55, my lord, whether that section was referred to at page 31.
Yes.
Section 55 shall provide to every person against whom complaint has been before act legal assistance to defend his case. So when you are only investigating or recommendatory body, all these sections would not have shown that you will give legal assistance. Where is the occasion for the complainant, for the accused to get the legal assistance when it is an administrative authority? Unheard of. My lord, none of these provisions have been referred to in the Supreme Court judgment. Now what was, kindly see my friend's which the recent judgment, kindly see Office of Lokayukta, my lord. Facts of the case, my lord, is that the complaint was made by the officer of Lokayukta for conducting the preliminary inquiry against MLA. MLA at that stage approached the High Court, and High Court quashed the very initiation of preliminary inquiry. So therefore the power of Lokayukta to conduct the preliminary inquiry was in question. And in that context, court held that it is a necessary party, my lord. Even inquiry, only complaint was filed. Your lordship, kindly see the facts. Director against judgment so and so, Mr. Ranjan Kumar, Deputy Superintendent of Police, Vigilance Cell, unit indicating alleged corruption against respondent number 1, who was elected as member of so and so, conduct a preliminary inquiry and submit a report to Lokayukta. Review petition was, and division bench set aside the very initiation of preliminary inquiry. And so therefore, my lord, who was before Lokayukta? It is the office of the Lokayukta which has initiated. And therefore, in that context, my lord, this judgment has to be seen. Because here, my lord, Lokayukta has exercised the judicial power. There, because your lordship has seen that when it comes there, the same organization will have 2 types of power. One administrative, one judicial power. My lord, if I take your lordship to the judgment of that, the judgment of Chief Justice in Gujarat matter, my lord, and that paragraph, Gujarat judgment, Kaji judgment, my lord, and the Kaji judgment, your lordship will see the High Court, the Honorable Supreme Court also says, my lord, in that judgment. Kindly see paragraph 6 at page 266, my lord.
Yes. Yes.
40, the Supreme Court has quoted this judgment at 266, my lord, 43, paragraph 43, page 266. It is extension of paragraph 6, my lord. Therefore, the proposition that can safely be culled out is that the authorities or tribunal who in law are entitled to defend the orders passed by them are necessary party. If they are not arrayed as party, it can be treated as not maintainable. My lord, kindly see these 3 lines. Therefore, the provision that can safely be culled out is that the authorities or tribunal who in law are entitled to defend the orders passed by them are necessary parties, and if they are not arrayed as parties, writ petition can be treated to be non-maintainable, or the court may grant liberty to implead them as party in exercise of judicial discretion. There are tribunals which are not at all required to defend their own order, and in that case, such tribunal need not be arrayed as parties. So, if there is an administrative order passed by the tribunal directing preliminary inquiry, my lord, and that order is interfered with, surely Lokayukta is a necessary party, and that is what the Honorable Supreme Court has held. It has not in any manner, in any way, digressed from the law laid down, my lord, that within the tribunal we have got administrative power, we have got judicial power. Here, my lord, it is a case of pure and simple exercise of judicial power. There is a complaint, public hearing, and the direction has been passed to register the FIR in light of complaint filed by respond number 3 before your lordship. So therefore, my lord, this judgment on facts of the case, and even in those provisions which I have cited, my lord, none of the provisions have been referred to because there was no occasion to refer to those provisions, my lord. Here, at the very nascent stage, at the beginning itself, when the preliminary inquiry was ordered, MLA approached the Honorable High Court, stopped the inquiry. Against that, review was also filed by Lokayukta. If your lordship will see, a review was filed and review was also dismissed. And then in that case, and your lordship knows the scope and ambit of Article 136, the power and power of the Honorable High Court, Honorable Supreme Court under Article 136 of the Constitution is quite wide, my lord. I have myself challenged in 2008 the order of Speaker under Article 136, even in 2003, a Speaker of Meghalaya directly in Supreme Court under Article 136. Therefore, the judgment has to be seen in this context, my lord, that therefore your lordship has rightly observed that place the Lokayukta Act, whether those provisions have been referred to in the judgment or not. And the principle of law is very clear, my lord, that if there is a quasi-judicial or tribunal, it is not required to be made party, my lord. I will file my written notes along with this on this aspect, my lord. Kindly give me some time, my lord, to prepare a note and give it.
I had a few responses, but
the sir rejoinder, so then I have to again some rejoinder.
It seems a little
sir rejoinder.
Lordship, it seems a little unfair to take up so much of Lordship's time on a matter which has been settled by the Supreme Court, my lord. The attempt, and I say this with whatever respect I have at my disposal, the attempt to distinguish the Supreme Court judgment of 2023, my lord, again, fault may be mine, but I could not understand the distinguishing factor, my lord. In fact, submissions advanced to try and distinguish have reinforced the fact that the judgment applies. In this 2023 judgment, the jurisdiction of the Lokayukta to pass the preliminary order was under challenge. Without hearing the Lokayukta, that order was set aside. Supreme Court said, you have natural justice has been violated, Lokayukta should have been heard. In our case, is there any difference? My Lokayukta's jurisdiction to have ordered for investigation, filing of FIR, etc., is being challenged by the state. It's exactly the same situation, my lord. I have to be heard as per what the Supreme Court has said in this judgment. So if written submissions are being allowed by my lord from the side of the petitioner, I'll also submit a bullet point.
Do that.
One clarification. Only one. Because my learned AG, he stated that district council is not controlled by the government. But practically,
no, we're talking about the establishment.
Yes, establishment.
Not control.
Control, but establishment. But he said that on the notification on 17/12/2018, they have appointed the state bureaucrat MCS as a secretary to the Guardians of the District Council, which means it's confused.
That is the controlling power.
It is controlling. That is what learned friends say, that it's not controlled by the state. If they are not controlling, then the state should not appoint the secretary to the.
Those are, like I said, those will be issues which will be taken up in the if the main petition is heard. parties have been heard. As far as the issue of maintainability is concerned, however, it is submitted that brief written synopsis of the argument may be allowed to be placed before this court with relevant authorities. As prayed for, seems allowed. This is matter
After by Monday I can file it. 1 week.
You said 1 week, you said 2 weeks.
Because the matter is still fresh in Lordship's mind. It should not disappear from Lordship's mind.
I'll file in written submission also, it will be there.
Up to my Lord. 1 week is more than enough.
This matter too.
Because there is some vacation also in between. There is a vacation.
Oh, yes.
Also. There is a vacation also.
So
2 weeks then.
2 weeks. Very good.
It will be in the first week of April.
Yes, madam. Lordship, that Odisha Act, I'll include it along with the written submission.
Yes, that would be.
Once I get it, then I will go through it, and then I will distinguish it also, that how it is different, distinguishable. My friend will have it by Monday.
You just request your colleague to download it from the net. I can also
So hopefully, if it is on their website, I will get it. I will get it.
Obliged.
But I don't know what is going to be my friend's argument on Odisha.
I have finished my arguments, madam. As I said, it's unfair to take up so much time. Obliged.
So item 5 also the same order.
Yeah, so same. Yes, Mr. Deb, you can also find your written argument.
Item number 6.
As you were saying,
Lordship, we have to file the reply of the affidavit in the...
oh, as far as those annexures are concerned,
Yes, Your Lordship. As the learned counsel is out of station, so we need 1 week time.
Ms. Counsel, appearing for the petitioner has submitted that affidavit in reply could not be 2D. You filed an additional affidavit,
Yes, Lordship, we have already filed here, Lordship.
counter or additional?
Additional affidavit, Your Lordship.
To the additional affidavit filed by the Union of India, Respondent Union of India. Oh, we have no to that the affidavit in reply to the additional affidavit filed by the Union of India could not be filed today and has sought for time in this regard. We allow. This is matter of 2 weeks.
Whatever, 1 week,
So I'll give you enough time, 2 weeks.
much obliged.
So 6 and 7 same.
Yes, Your Lordship, it's a connected matter.
It's a connected matter, Your Lordship, but in item number 7, the pleadings have been completed, Your Lordship.
Oh, been completed.
Yes, Your Lordship.
So 7 should list matter on.
Much obliged.
Item number 8.
May it please Your Lordship. Lordship, I'm appearing on behalf of the respondent for Your Lordship. The conducting counsel P. Nongbri, he has to leave the premises, Your Lordship, due to some personal difficulty, Your Lordship. I pray for some accommodation in this matter in this regard, Your Lordship.
No objection, Lordship.
On pre-made by the respondent number 4 on behalf of the learned counsel for the respondent 4 who is said to be personally indisposed. The same not be objected to by petitioner. This is matter up to 2 weeks.
Much obliged, Lordship.
Item number 11.
Yes, Mr. What are the records?
Lordship, they are record. I have brought the record. So.
Yes, Mr. C. What is this matter about?
This is Lordship, dismissal from service, Lordship. I have raised few law points, Lordship, in this. That I was not given the list of documents as well as list of witnesses along with the show cause notice. Then I was not allowed to give the opportunity to cross-examine the witnesses. The witnesses were examined on the same day, government witnesses. Then so far as the issue with regard to Rule 9.2, which says that the show cause notice must accompany the list of witness and list of documents. With regard to that issue, I have relied some authorities, Lordship, that this is a mandatory provision and any deviation from the settled law says that the proceeding will be vitiated. Now, after the DP, Lordship, I was not given the copy of the inquiry report. That also I have referred some full bench judgment of the Honorable Constitution Bench of the Honorable Supreme Court, Lordship. Then on the previous occasion, Lordship, I have raised one pertinent issue, Lordship, that the disciplinary authority did not appoint the presenting officer on behalf of the government who will present the case of the government against the delinquent.
Who conducted the proceedings then?
Here, the inquiry officer. He, in absence of presenting officers, he has acted as a judge as well as the prosecutor. The law says that he cannot. So on that ground, I have relied one judgment. Later on, my Lordship has pleased to ask the state respondent to place the original records of the DP proceeding, Lordship. Now here another pertinent issue I have raised, Lordship. In the inquiry reports, my past history were not reflected because that was not the part of the charge. But in the in-pin order, they relied my past misconducts and they have imposed the major penalty, Lordship. So, Lordship, if the records, I'll just today, in fact, I thought that my learned senior will place that original records. After that, I'll just make effective reply on that, Lordship.
I have not made my submission, Your Lordship.
Yes.
I have not made my submission.
Yes, true. After that, I'll.
You can reply on it.
Yes.
Please.
May I start, Your Lordship? I may persist, Your Lordship. Lordship, before I take to the affidavit, Lordship, I would, Lordship, kindly come to the Annexure 2 at page 16 of the writ petition.
Yes.
Lordship, these are the charges and the statement of allegation against the petitioner that he were found absent from with effect from 15/12/2020 without any leave permission from the competent authority, Your Lordship. 3 notices have been issued, Your Lordship, to him, Your Lordship. In spite of the fact that he had received the notice, he did not bother to resume the duty, Your Lordship. That is reflected from the record, Your Lordship. Then to page 17, page 18, Your Lordship, these are the statement of allegation. Statement of allegation, Your Lordship. And at page 20, Your Lordship, kindly see at page 20, Your Lordship, of the show cause filed by the delinquent employee, Your Lordship.
Page 20.
Lordship, yes. This is the type copy, Your Lordship, because the true copy cannot be read, Your Lordship. This is the type copy. Lordship, kindly come to paragraph 1.
Yes.
So it is the admitted fact, Your Lordship. It is the admitted fact, Your Lordship, that the delinquent employee, Your Lordship, admitted to the charges. He admitted to the charges. He admitted to the charges. Then, Lordship, another contention, Your Lordship, that the petitioner has not been afforded. This fact also, Your Lordship, this fact also that the petitioner admitted also, even in the course of the department proceeding also, Your Lordship, the petitioner admitted to the charges. Lordship, can we have the affidavit? Lordship, can we come to page 20? I got to go judgment. Admission of charge. Lordship, at page 20, Your Lordship, to the affidavit filed by the state.
Yes.
Lordship, kindly see, my name is so-and-so, so-and-so. In response to the charge alleged against me, I am to state that I admitted that I was absent from duty with effect. So the fact, Your Lordship, we have admitted, Your Lordship. And to that, Your Lordship, I would like to place a law on this regard. I got over 1972. Lordship, regarding the admission of charge, Lordship, kindly, this is 1971 1 SCC 1, Your Lordship.
Yes.
Lordship, kindly come to paragraph 4 and 5.
Yes.
May I read it, Your Lordship?
Please.
The plea of the petitioner are quite clear. In fact, he admitted all the relevant facts on which the decision could be given against him, and therefore it cannot be stated that the inquiry was in breach of any principle of natural justice. And an inquiry fact have to be proved, and the person proceeded against must have an opportunity to cross-examine the witnesses and to keep his own version or explanation about the evidence on which he is charged and to lead this evidence. In this case, the facts were twofold: that he had stayed beyond the sanctioned leave and that he had proceeded on a fast as a demonstration against the action of the authorities and also for what he called the upliftment of the country. These facts were undoubtedly admitted by him. His explanation was also there, and it has to be taken into account. That explanation is obviously futile because persons in the police force must be clear about extension of leave before they absent themselves from duty. Indeed, this is true of every one of the services unless, of course, there are circumstances in which a person is unable to rejoin duty, as far as, for example, when he is desperately ill or otherwise reasonably prevented from attending his duties. This is not the case here. The petitioner took upon himself the decision as to whether the leave could be extended or not and acted upon it. He did not go on. He did go on fast. The later explanation was that he went on fast for quite different. The inquiry officer had to go by the reason given to him. On the whole, therefore, the admission was one of guilty insofar as the fact on which the inquiry was held and the learned single judge in the High Court was in the apparent right in so holding. So, he admitted, Your Lordship. In this case also, he admitted to the charge, Your Lordship. Then kindly see para 5, Your Lordship. It was contended on the basis of the ruling reported in so and so that on the facts admitted in the present case, a plea of guilt ought not to be entered upon the record and a plea of not guilty entered instead. Under the English law, a plea of guilty has to be unequivocal, and the court must ask the question, and if the plea of guilty is qualified, the court must not enter a plea of guilty but one of not guilty. The police constable here was not on his trial for a criminal offence. It was a departmental inquiry on facts of which due notice was given to him. He admitted the facts. In fact, his counsel argued before us that he admitted the fact but not his guilt. We do not see any distinction between admission of fact and admission of guilt. When he admitted the fact, he was guilty. The facts speak for themselves. It was a clear case of indiscipline and nothing else. If a police officer remain absent without leave and also resort to force or as a demonstration against the action of the superior officer, the indiscipline is fully established. The learned single judge in the High Court was right when he laid down that the plea amounted to a plea of guilt on the fact on which the petitioner was charged, and we are in full agreement with the observation of the learned single judge. Then, Lordship, another decision, Your Lordship, I'll like. Another one, Your Lordship, is 2008, Your Lordship. 2008, 5 SEC, 569, Your Lordship. Para 16, Your Lordship, 18 and 19.
Para?
Lordship, para 16. 16, 18 and 19, Your Lordship. Indisputedly, the respondent was a habitual absentee. His explanation in answer to the charge sheet pleaded guilty, admitting the charges. In terms of Section 58 of the Evidence Act, charges having been admitted were not required to be proved. It was on that premise that the inquiry proceeding was closed. Here, Your Lordship, even the just in this case, Your Lordship, on the fact that the employee admitted there was no further inquiry, Your Lordship. It was on the premises that the inquiry proceeding was closed. Before the inquiry officer, he did not submit the explanation of his mother being ill. He, despite opportunities granted to report to duty, did not do so. He failed to explain even his prior conduct. In so and so, Your Lordship, in terms of the aforesaid provision, thing admitted need not be proved. In view of the admission of the respondent alone, the issue of Asrika allotment so and so should have been answered in favor of the appellant. The company petitioner at a much later stage could not be permitted to take a stand which was contrary or inconsistent with the original pleading, nor could be permitted to resile from admission contained therein. It was observed that judicial admission can be made the foundation of a subsequent explanation before any other authority which had not been pleaded in the departmental proceeding cannot by itself be a ground to hold that the principle of natural justice had not been complied with in the disciplinary proceeding. So, Your Lordship, in this case, Your Lordship, exactly the case here, Your Lordship, the petitioner admitted to the charges, Your Lordship. Admitted to the charges, Your Lordship. In fact, in my humble and respectful submission, Your Lordship, the inquiry officer ought to have stopped the inquiry at that particular point of time, Your Lordship. But still, the inquiry officer, Your Lordship, had chosen himself to afford a chance to the delinquent officer. And during the course of the departmental proceeding, Your Lordship, he did the same. He admitted, Your Lordship. Lordship, I have given in page 20 of the affidavit filed by us, Your Lordship. He admitted, Your Lordship. Then, Lordship, another decision is 2009. 15 SEC 620, Your Lordship. Lordship will kindly come to paragraph 13 and 14.
Yes. Yes.
It has been time and again said that it is not open to the High Court to examine the finding recorded by the inquiry officer as a court of appeal and reach its own conclusion, and that the power of judicial review is not directed against the decision but is confined to the decision-making process. In a case such as the present, where the delinquent admitted the charges, no scope is left to differ with the conclusion arrived by the inquiry officer about the proof of the charges. In the absence of any procedural illegality or irregularity in the conduct of the departmental inquiry, it has to be held that the charges against delinquents stood proof and warrant no interference. The single judge of the High Court in para 43 and 44 of the judgment observed thus. Then, Lordship, I kindly come to the next. In what we have already discussed, we find it difficult to accept the view of the division bench like this fell in not adverting to the fact that the charges were admitted by the delinquent unequivocally and unambiguously, and therefore misconduct was clearly established. We are therefore unable to persuade ourselves to concur with the view of the High Court. Lordship, these are the decision regarding that admission of charges, Your Lordship. Then, Lordship, another contention is that the non-supply of the report of the inquiry. Before I come to the fact, Your Lordship, kindly come to para 9 of the writ petition, Your Lordship. Para 9 of the writ petition, Your Lordship. That report of the inquiry has been made part and parcel of the writ petition, Your Lordship. And the condition that the report of the inquiry has not been furnished, Your Lordship, in my humble and respectful submission, Your Lordship, is not factually correct, Your Lordship. Assuming, Your Lordship.
So the inquiry report is already.
Yes, Your Lordship.
Next,
Your Lordship, a copy of the inquiry report submitted by inquiry officer is enclosed herewith and marked Annex 9. Annex 9 is the report of the inquiry, Your Lordship.
Yes.
Lordship, at page 26. That is the report of the inquiry. Lordship.
Yes.
Assuming but not admitting that the report of the inquiry as contended has not been supplied, Your Lordship, to the petitioner, Your Lordship, if that has not been done, Your Lordship, then the petitioner has to plead prejudice. He has to show what prejudice has been caused, Your Lordship, by non-supply of the copy of the inquiry report. In just a mere non-supply of the copy of the inquiry report, Your Lordship, in my humble and respectful submission, Your Lordship, will not be shared the departmental proceeding if the charges on which the inquiry, on which the departmental proceeding had been initiated against the petitioner, he himself had admitted the charges, Your Lordship. That will not be shared, Your Lordship. To that, Your Lordship, I'll please some case law, Your Lordship. This is 2001, Your Lordship, SEC, SCC. Lordship, this is 2001-6 SCC. Lordship, kindly come to para 12. Para 12, Your Lordship, at internal page. Lordship. Thus, Lordship is with me.
Yes.
From the case of ECIL, Your Lordship, which was heavily relied by the petitioner, Your Lordship, it would be plain that in cases covered by the constitutional mandate, Article 311(2), non-furnishing of inquiry report would not be fatal to the order of punishment unless prejudice is shown. If for infraction of the constitutional provision, an order would not be invalid unless prejudice is shown, we fail to understand how requirement in the statutory rule of furnishing copy of the inquiry would stand on a higher footing by laying down the question of prejudice is not material therein. So, Your Lordship, we has proved what prejudice has been caused, Your Lordship, by non-furnishing of the report of the inquiry. Nothing has been stated, nothing has been pleaded, Your Lordship, in the writ petition. Then another decision, Your Lordship. 2008, Your Lordship. This is 2008, Your Lordship. 9 SCC 31. Lordship, kindly come to para 17. May I read it, Your Lordship? The attention of the court, whether Lordship is with me.
Yes, yes. Please.
The attention of the court was invited to certain decision wherein in a different note had been struck by this court. Reference was made in this regard to the three-judge bench decision of this court in Kailash Chanda so and so, wherein it was held that non-supply of the report of the inquiry would not ipso facto vitiate the order of punishment in the absence of prejudice to the delinquent. Though Muhammad Ramzan Khan was decided subsequently, Kailash Chanda was not brought to the notice of the court. The bench therefore felt that the matter should be placed before the larger bench, and accordingly the registry was directed to place the paper before the Honorable Chief Justice of India, so that an appropriate action can be taken by so and so, Your Lordship, heavily relied. Accordingly, the matter was placed before the concerned bench. The concerned bench observed that the basic question of law which arose in the matter as to whether the report of inquiry officer appointed by the disciplinary authority to hold and inquiry into the charges against was required to be furnished to the employee to enable him to make representation to the disciplinary authority before such authority arrived at its own finding with regard to the guilt or otherwise of the employee and the punishment if need to be awarded to him. On the basis of the above fundamental, certain other incidental questions were also raised by the Constitution bench, which include the effect of non-supply of the inquiry report. So far, then Lordship kindly skip that and kindly come to para 20, Your Lordship. Para 20, next page, Your Lordship, internal page 38. Yes. Holding, Lordship Korean.
Yes.
Holding that it was incumbent on the delinquent employee to show prejudice, the majority held that non-supply of report of the inquiry officer to the delinquent employee would not by itself make the order of punishment null and void or non-ess. So it's very clear, Your Lordship. Then another decision, Your Lordship, on the same issue is Union Bank of India. Para 9, para no.
Yes.
This is 1994 SCC 310. Lordship, kindly come to the Lordship, kindly come to para 12. May I read it, Your Lordship?
Yes, please.
After hearing the rival contention, we are of the firm view that all the four charge sheets which were inquired into relate to serious misconduct. The respondent was unable to demonstrate before us how prejudice was caused to him due to non-supply of the inquiry authority report finding in the present case. It needs to be emphasized that in Lordship, in the banking, in the banking business, absolute devotion, diligence, integrity, and honesty needs to be preserved by every bank employee and particularly the bank officer. It is for this reason we are of the opinion that the High Court had committed an error while setting aside the order of dismissal of the respondent on the ground of prejudice on account of non-furnishing of the inquiry report, finding to him. So, Lordship, it reiterates, Your Lordship, that prejudice has to be pleaded, has to be shown, Your Lordship, which are absent, Your Lordship, in the present case. Then another decision, Your Lordship, is 2005, Your Lordship, SEC 264. Lordship, kindly come to para 25. Para 25, Your Lordship. The residual question is, what would the appropriate direction in such a case stand to the employer is that it could have justified the order of this termination by any evidence, even if it was held that there was some defect in the department proceeding. The solution is found in what was stated in the code of so and so in para. In all cases where the inquiry officer is not furnished to the delinquent employee in the disciplinary proceeding, the court and the tribunal should cause the copy of the report to be furnished to the aggrieved employee if he has not already secured it before coming to the court tribunal, and give the employee an opportunity to show cause how his or hearing the party, the court tribunal, come to the conclusion that the non-supply of the report could have made no difference to the ultimate finding, and the punishment given the court tribunal should not interfere with the order of punishment. So, Your Lordship, here in this case, Your Lordship, suppose, Your Lordship, the inquiry report is not there, Your Lordship. Lordship will direct me to furnish the report of inquiry to the petitioner and to show his prejudice. But in this case, Your Lordship, as I have pointed out, Your Lordship, in para 9, Your Lordship, he has the report of inquiry with him, Your Lordship. He did not plead prejudice. By not furnishing, what prejudice, Your Lordship? That has not been pleaded. It's silent, Your Lordship. Lordship, another. This is from our Guwahati High Court, Your Lordship. This is 2006, Volume 3, GLR, Your Lordship, 337.
Yes.
Lordship, kindly come. Lordship will see at para 6.
Yes.
The consequent emending from non-furnishing of a copy of the inquiry report to the delinquent prior to the imposition of punishment is no longer res integra. The question has been dealt with in so and so, Your Lordship. The case relied heavily by the petitioner, where the law laid down has been found manifestation in numerous other judgments, following to judgment which we have considered appropriate notice. The first is the judgment in the case of so and so, so and so. The consistent view taken by the apex court in this regard is that the right to represent against any punishment proposed on the basis of the report is a part and parcel of the doctrine of reasonable opportunity enshrined by the principle of natural justice and the provision contained in Article so and so of the Constitution. Consequently, a delinquent has a right to represent against the finding of the inquiry report at any stage prior to the imposition of the punishment by the disciplinary authority. Thus, the law laid down is to the effect that if the inquiry report is not made available to the delinquent officer prior to the imposition of the punishment on him, such failure would violate the principle of natural justice. However, managing director case and the other judgment referred to above strike a note of caution. The apex court has laid down that interference with the punishment imposed will be justified only in a situation where prejudice has been caused to the delinquent by non-supply or non-furnishing of the report of the inquiry. to the delinquent. Merely because such a report was not furnished to the delinquent before punishment was imposed by the DA, the court is not to presume that prejudice has been caused to the delinquent. The Apex Court has further laid down that in such a situation, the proper course of action for the court would be to ensure that the delinquent is furnished with a copy of the inquiry report, and thereafter he should be heard on the point of prejudice. Only if prejudice to the satisfaction of the court is proved to have been caused, the punishment imposed would be interfered with, and the matter would be remanded or for recommencement of the proceeding from that stage, and the last known status of the petitioner should be restored till the recommendation inquiry is completed. That is not the case here, Your Lordship. The case here, Your Lordship, you have the report of the inquiry now. Then another decision, Your Lordship, is a very Lordship, another is a 1 page 1996, Your Lordship. Pardon. (1996) 6 SEC 415, Your Lordship. Lordship, kindly come to para 3 of that order, Your Lordship. The only controversy raised in the High Court was that he was not supplied with a copy of the inquiry report. The order of dismissal was barred in law. The learned single judge as well as the division bench of the High Court have considered the effect of the judgment of the constitution bench of this court in so and so. The learned single judge as well as the division bench had asked the petitioner what prejudice the petitioner had suffered for non-supply of the. Since there was no adequate explanation offered by the petitioner, the High Court came to the conclusion that though the copy of the was not supplied on the fact as no prejudice was proved, it was not a case wanting interference. Then, Lordship, another content before I take to another, Lordship, kindly see the report of the inquiry, Lordship, at page.
Should we continue in the second half?
Lordship, I'm sorry. What to do? 15 we can. Or we continue also. We finish it. Or what do you say? 15 minutes. Yes, we can
conclude on we can continue on 15, Lordship. 15, because I'll take some time to respond what my learned senior is saying. He is citing some judgment with regard to violation of 311. That so far other technical issues which I have raised. On the last occasion, Lordship, I have raised that presenting officer. That is why.
Then also I'll come one point by point, Your Lordship. I'm making a point by point argument, Your Lordship.
No, this court will not be there on 15.
On 15.
I think we have to go to the second week of April.
Then we can have on 23rd, Your Lordship, if Lordship is
23rd.
Huh?
Why not?
Oh, sorry, I'm looking at that calendar. I'm looking at that calendar, Your Lordship. I'm sorry. Then if that be the case, then you'll come in the first week of April on, Your Lordship.
Heard Mr. Assistant Learned Counsel for the petitioner. Also heard Mr. Insurance Learned Counsel, Learned AAG for the state respondent. The hearing is yet to be completed. The same will resume after 2 weeks.
Awesome.
Item number 12.
How many more matters we have?
But I have 3 matters, my lord. 12, 13, 14, 15. These are NDPS bails granted by the trial court, my lord. And we have challenged those bail orders on merit, my lord. But I have to place many citations in this, my lord. Today may not be possible because
After 2 weeks, on pre-made by the parties. Lists matter to 2 weeks. That is 12, 13, 14 till 15.
12 to 15.
You are there.
I'm for 13, 14 and 15.
I'm for number 12. This one is number 12.
Understood?